We appreciate you being with us this holiday weekend. I'm Jason Whiteley. It's not just Californians that see something in Texas with so many of them moving here, but the governor of California now wants to copy the Texas abortion law. Part of it, at least, specifically the part saying that the state does not have to enforce it. Instead, regular folks can in court by suing as many times as you want. California Governor Gavin Newsom wants to use that specific mechanism that the Supreme Court did not immediately strike down. He wants to use that to go after assault rifles and homemade guns. That controversial Texas law is our focus of our first interview. The author of the bill was Bryan Hughes, a Republican state senator from Mineola in East Texas. Senator, welcome back to our program. Glad you are here. Let's talk about SB 8, the fetal heartbeat bill. It survived the challenge, temporarily at least, at the U.S. Supreme Court. Justices left it in place, but they also said that the abortion providers can still continue to challenge it in court. How significant is that ruling in light of Roe versus Wade and the future of Roe versus Wade?
Jason, thanks. That ruling on Friday was a total victory. We're very encouraged. The Supreme Court left the law in place, as you say. They did allow the challenges to certain state agencies, but those agencies have nothing to do with the Texas heartbeat law. So the law remains in effect. And again, it continues to save little lives, little unborn babies that are growing inside their mother's wombs. And so we're very excited. We were happy with that Supreme Court ruling and really just could not be more pleased.
The Supreme Court really seems poised to potentially overturn Roe v. Wade this term, either with the Texas bill, Texas law, your bill there, or with the Mississippi law that bans abortions after 15 weeks. But abortion providers, Senator, I'm sure you're seeing, they say that this is simply going to drive abortions back underground, puts women's lives at risk, or women would be forced to carry a pregnancy to term. What do you say to those folks?
Well, Jason, I believe you're right. The Supreme Court looks like this Mississippi case is going to be reviewed favorably by all indications. We're excited about that.
California is modeling a law after SB 8. I'm sure you saw the note from Governor Gavin Newsom out there. He wants to ban assault rifles and ghost guns, those guns without any firearms made at home without any serial numbers. But like Texas, the state of California is not going to enforce it. Instead, California is going to let people sue over it as well, too. Are you concerned that you might have created something here that could spread across the country uncontrollably?
You know, I've heard the argument. It's interesting. If you look at guns back in the 90s, you'll recall back in the 90s, the left tried to go after the gun manufacturers using the courts. They tried that back in the 90s and they failed. Today, we are using the civil courts to save little unborn babies, and we're succeeding. So I don't blame Governor Newsom for being upset, but they've already tried that. The enforcement mechanism in Senate Bill 8, the citizen enforcement, does not mean, it doesn't prevent judicial review. There's still judicial review. This enforcement mechanism is only effective in a situation like Roe, where there's a so-called constitutional right that's in jeopardy. In the case of the right to keep and bear arms, the Second Amendment says the right of the people to keep and bear arms shall not be infringed. It's in the Constitution. It's been consistently upheld by the courts. And so the enforcement mechanism we use in Senate Bill 8 is not effective against the right to keep and bear arms because it's a constitutional right in the Constitution, and it's been consistently upheld by the courts. Whatever you think about Roe, I think even its most ardent defenders will agree that Roe versus Wade is on shaky ground. And because everybody knows the Supreme Court may overturn Roe or hollow it out very soon, that's why the mechanism we use in Senate Bill 8 is so effective. So it doesn't work against gun rights, free speech. It's because those are legitimate rights backed up by the courts.
Senator, another one of your high-profile bills that were signed into law is the one forbidding social media companies from banning users for sharing their viewpoints. A federal court has blocked that bill right now, saying social media platforms do have a First Amendment right to moderate their content. Should you have written that one any differently?
It's a great question. You know, we looked at what Florida did. We did ours a little different from theirs. We believe that we're going to prevail in that case. Again, we respect the courts. We respect the constitutional system. The judge who temporarily blocked the social media censorship bill is the same judge who tried to block the heartbeat bill. And we're appealing to the same Fifth Circuit Court of Appeals. And we're optimistic. We believe the law is constitutional. It's going to be upheld. So, yeah, we feel good about it. Now, again, if they find some reason to strike it down, or to limit it, yes, we'll go back and tweak it and send it back to them. We're not going to give up. We're not going to, have them looking over our shoulder. But we believe the law is going to be upheld.
Senator, thank you for the time. We appreciate it.
Thanks for having me.